So what we did was, first of all, I'd like to clarify something the chairman said on the new address for license applications. That has nothing to do with renewals. Renewals still go to M&T, just in case there was any confusion there. So what I did was I had my staff give me input on what they're seeing, repeated deficiencies that we send out letters on over and over again. So I just want to bring up a few of the items that they have provided to me. I'm going to go chronologically through the application. The very first page of the application where you're listing the email address, it should be the email address of the applicant of the premises, not your address. If they ever choose not to use you in the future, all their documents are going to be going to an attorney that's no longer employed by them. A clear organizational chart, when you have an applicant that has a bunch of holding corps or LLCs underneath that, we should see those LLCs listed and who is in those LLCs and the percentage of the ownership for those people. If it's a publicly traded company, you can just note that it's publicly traded. You don't have to go through and list anyone. On the second page of the application is where we list the principals. That is where our clerical unit obtains the information to data enter into our system. They're not thumbing through and looking through for the personal questionnaire and taking the information from there. So make sure that the information on page 2 is correct. You verified it, that you looked at their passport, you spelled their names right, social security number is right. We get a lot of emails and licensing information where we've asked for people to be fingerprinted when they actually are already licensed. That's because the name was misspelled or the social security number was wrong, and when clerical ran it, they didn't find anything. So therefore, we asked for them to be fingerprinted, which was not necessary.
No, just to add to what she's saying, you all are being paid to fill these applications out. The fact that you can't get the social security of your client correct amazes me. Take the card if you have to and read off of that. But that in and of itself slows our process up that you cannot imagine when you just get one digit off or you're not spelling their name correctly. It just amazes me that you're charging a fee and we're on the second page. And how often do you see that? Daily, correct?
I would say at least once a week.
I mean, it's amazing.
I'm finding that principals, I know we're 5 months behind pretty much, are still not being fingerprinted when we go to pick up that application. You should be telling your clients that, hey, you get that receipt and it says you need to be fingerprinted, you need to go and get that done. And here I will give you an example of what happened just last week. The gentleman did not disclose that he was a felon in another state. So had he went and gotten fingerprinted 2 weeks in, he may have had the 3 months to get the proper documentation. Now we're at the approval stage, and, oh, he's got a felony. Well, do you have a certificate of relief? No, I don't. And everyone in here in this room knows it takes months to get that sometimes from the court. So it's really important that these people go out and get fingerprinted so we can take care of that early on. Right to premises. Your client does not own that property unless it is in the name of the applicant applying. They can own it under another corporation they formed, but that still makes it that you need a lease. So if the name on the deed and the name on the application does not match, we need a lease for that property. That happens quite frequently. The landlord identification. Very seldom do we get the landlord's home address. It's blank most of the time. And the reason why we want that information is because if I'm looking up James Hall in our system, because we have to run every name that we see in that application to see if they've been licensed, and there's more than one James Hall, it's going to take me a while to go through and figure out which guy could be mine. And if he could be mine, now I have to go check to see, has he been revoked, canceled? I mean, we check the history on everything, so if we really do need that home address for the landlords so we can verify whether they have a history or not with the authorities. Financial disclosure form. Large deposits need to be explained. You know, maybe it was an insurance settlement, whatever that case may be, we need to know where that money's coming from. I've seen a lot where we get one bank statement and there's a bunch of deposits, and look, they do have the $200,000. Well, that's really not the source of the money. The source of the money is coming from all those deposits. So we need to know what those bank accounts were. Where is the money coming from? Were they his other bank accounts? Were they loans? We don't know, so therefore we have to send a deficiency and we have to ask for it.
And that's something that I've seen we have to ask for 2 and 3 times. And I think the message here is send more in. Nobody's getting their hands on this. It's not foilable, these bank statements. So just send everything in rather than us sending 3 letters out.
All lenders, donors, and joint account holders must submit a personal questionnaire. That, I will say, that was a problem maybe a year or 2 ago. That's gotten better, but we still get people that don't submit those items. 500-foot statement. Make sure you're checking the appropriate box. A lot of people just check there isn't any. Well, there isn't any need for it because the population's under 20,000. Each time something comes in, we got to look up the population to see, did they catch that? Did they not catch that? So double check that. Public interest statements. We are getting applications without them. We no longer schedule 500-foot hearings without a public interest statement. If the application comes in, it just goes on its merry way until the deficiency letter. So now, if and when we ever do get caught up, you might hold up your applicant because now we've got to schedule a 500-foot after the deficiency's gone out, and that should be getting closer to the end of the process. You should not be sending the same general public interest statement with every application you file. I've seen it. I've looked up somebody's applications, same exact sheet of paper in every single one. I mean, there's got to be something special about each thing that's being opened up in those neighborhoods. You got to get the Italian place, the first Mexican place, something. The 200-foot law. If you are telling me that there is a church 146 feet away from the proposed premises, and you're telling me that it's not exclusive, could you please attach a statement and tell me why it's not exclusive? Did you already interview the pastor? How did you figure it out? Because I'm starting from scratch now when I'm looking at it. How did you determine that? Any kind of inference you can provide would be helpful. We're starting from scratch, trying to figure it out. It takes time. A lot of times I go to Google Maps, I put the little man down, and I walk around the perimeter of the property to see what's there, because I can't go to each place just to see if I can notice something. Is it in a plaza? What's the deal with it? The establishment questionnaire and diagrams. Outside areas need to be contiguous with the interior. Can't walk out the front door, walk down the sidewalk, and walk into an enclosed area that has no way of getting inside. People need to be able to get to the outside area from the interior of the premises. You can't walk on a public street to enter into it. You can't have one across a sidewalk into a little grassy area. That's more common upstate than it is down here. But everybody needs to be able to walk right out and empty right into the contained area. Any outside area should be depicted on the diagram for the floor that it's on. So a sidewalk cafe would be on the ground floor diagram. A second floor terrace would be shown on the second floor diagram. For some reason, people don't add any outside areas when they send in diagrams. If you don't disclose an outside area to your community board or your municipality, don't put it in the application unless you've already obtained a letter from the CV that they acknowledge that there will be an outside area and they're okay with it. We're going to kick it back in a deficiency letter and say you either need the letter or you need to remove it from the application. Diagrams should show any doors. It should show where the bars are, where the kitchen is, where the food prep is. Measurements would be helpful. I won't kick that back for no measurements as long as I can tell from the photos. Basically the scale of the room, because obviously an 8.5 by 11 sheet of paper doesn't give you the scale. Architectural drawings are very difficult to read. They're a nightmare. So if you can avoid those, please do that. I'm not an architect. Staff isn't an architect, and they put way too much information in there down to what kind of flooring is being used, I mean, you just don't know what half the stuff is on there. Block plot diagrams can't be Google Maps overhead. A lot of people just send that in thinking that's fine. That's not sufficient. Nothing's been labeled. Sometimes they're hard to read. I mean, if you're in upstate New York up in the Adirondacks and there's 3 buildings next to a restaurant, that's one thing. But down here, it's impossible to use those. Restroom waivers. They are required when there is not a restroom within the licensed premises. I don't care if it's around the corner from the premises, you're in a communal dining hall, whatever the case may be. If you don't have a restroom within your premises, I need a restroom waiver. You need to tell me where that restroom is, how far it is away from where your patrons are drinking and eating. Method of operation, same thing with the community board. Don't add things in after you've told the community board that you're not going to have a DJ, and now your application comes in and I'm reading DJ on there. We're not going to let that go through. You're going to have to remove it, or again, provide a letter from the community board that they've approved it.
And just to add to that, we get a lot of that at the board, and you're going to get denied at the board if that happens, if it's inconsistent. Because that is, in my mind, a red flag that you're telling them one thing and then telling us another. So if it even gets that far, ideally it shouldn't, but if it does, that's going to end up in a denial.
Personal questionnaires. We require 5 continuous years, the last 5 continuous years of employment history and address history. A lot of times we're not provided with that. I also see a lot of just non-answered questions. Have you ever had a license? It's blank. They don't answer yes or no, and they don't fill anything out. We need to know that information. A lot of times I'll let it go if they've had it and they didn't have any adverse history. But these questions really should be completed for the examiner.